Laurie Smith's case ultimately wound up in the Supreme Court, which is when reporters started noticing some weird things about it, like the fact that it was built on a hypothetical. As ADF's legal filing stated, Smith was not at that time in the wedding industry, but just wanted to make sure that if she entered it, she'd be able to legally turn down same-sex couples. In fact, at the time the suit was filed, she'd had no requests from same-sex couples to design a site. She did later claim she'd received an inquiry which oddly arrived the day after her suit was originally filed. That request was apparently from someone named Stuart, who contacted her about building a website for his wedding to a man named Mike. But it turned out he was actually a straight man who, at the time the request was sent, had been married to a woman for nearly a decade and has since sworn he'd never requested anything from Laurie Smith. And why would he? Because even if he was secretly engaged to someone else, which he wasn't, and chose to break the news of that secret engagement with the creation of an artistic website, which he wouldn't, at the very least, he'd probably choose to go with a wedding website design business that already existed. But if we're being really honest, he wouldn't do that either, because he was, and this is true, a fucking website designer. And what a phone call that must have been for him to receive. Guess what, buddy? Some lady said you're getting gay married and now the Supreme Court is involved. You need to call your wife. But it doesn't stop there, as other cases in that flurry of lawsuits were similarly wobbly, because while ADF insists our clients are real people who had or still have real businesses with actual operations in the wedding industry or real plans to enter it, the Washington Post found that 2 of 3 vendors cited in ADF's petition to the Supreme Court had stopped working on weddings. One had actually moved away from where the case was filed in Louisville, but ADF claimed she'd still be willing to take work there, despite it being 600 miles from her home. Not only that, ADF had also had a hand in formally establishing companies for some of its clients, with lawyers associated with the group signing incorporation paperwork and helping draft company policies. In one instance, only a month before a lawsuit was filed. But none of that mattered, because when Laurie Smith's case went in front of the Supreme Court, she won a much broader ruling than ADF had with the cake shop. And as Justice Sotomayor wrote in her dissent, it was a decision that for the first time in the court's history grants a business open to the public a constitutional right to refuse to serve members of a protected class.